Hello, thank you for joining. Our topic today is litigation management for inside counsel. Now, here's the precursor to this. I have never been inside counsel. I've always been outside counsel. But I've learned a little bit about what inside counsel needs. And so I'm trying to convey a little bit of the perspective that I've gained that might help you. And so that'll be sort of the focus of my presentation. There will be slides that come with this, and you're perfectly capable of reading the slides. But the first line on the first slide is, avoid litigation whenever possible. There is generally a negotiable solution to most disputes. And of course, it takes two parties to tango, right? It takes two people to dance, right? But if there's a way to avoid it, that's always kind of nice. I guess the broader thing I would also say, because I think I'm talking to some GCs or assistant GCs, is litigation does not really help the C-suite people, right? It's an inconvenience, it's expensive, and to the extent it can be avoided, you'd be very popular. Okay. So the next thing I have to suggest is that corporations should develop principles and educational programs to guide the employees on how to avoid litigation. It would be great if we could not have a case in the first place, if that makes sense. Outside counsel, and you really don't need outside counsel to do it. You can do it yourselves. But the trick is to develop litigation awareness and put principles and guidelines in place for employees. We are in a place in this world where people are highly sensitized. And what we want to do is respect them on the basis of all those qualifications. And as lawyers, it's our obligation to do that. It's our obligation as outside counsel or inside counsel to understand and respect those considerations. And we also have to be deferential to generational considerations. I was born in 1966. A lot of our coworkers are a touch younger than I am. And the thing is to be sensitized to what their needs and values are. And I think it's extremely important. And I'll hearken back to what I said earlier. If we could avoid litigation, wouldn't that be lovely? So, as an in-house lawyer, that's really your role, right? So there you have it. Yeah, so the next thing on my slide is consult with an attorney before a dispute arises. If you have any doubts, bring in counsel. It's no shame on you. Bring in counsel and try to work it out. It often is very productive. And it often will save you, I don't know, $500,000, $1 million, I don't know. So what the slide will tell you is such consultations can prove cost-effective and preventative at a small fraction of the cost if litigation incurs. And I highly recommend that to you. And if you can head this stuff off at the pass, you'll be appreciated as well. All right. If you have a serious dispute that honestly is looking like it's going to litigation, which, by the way, you wish to avoid, get a subject matter skilled lawyer to review the transactions and the contracts that are at issue between the parties. It's very important. Arbitration clauses, choice of law clauses, meet and confer clauses, termination clauses. These are things that are very important. And so I would highly recommend that to you. The other thing is when you have an impending dispute, I would highly recommend a document retention email to anybody who might have relevant documents or emails. It's traditional, right? And I won't cite you the cases, but it needs to be done. Tell them not to delete the emails and not to delete the documents. And I will leave it to you lawyers to figure out the importance of what we call upjohn, UPHGON warnings. Because without upjohn warnings, things can be a little bit sticky. I would also advise consideration of alternative dispute resolution. Whether it's in the employment contract or not, it works very well and it keeps stuff quiet. Now, we can't stifle employees from sexual harassment issues. That's fairly well established, and I would not recommend it morally anyway. But you want to be sort of guided by whatever the rules in the jurisdiction are, and you want to be careful of that. Other than that, private mediation or skipping that, arbitration, even if it's not in the contract, I would recommend considering it. It tends to make things a touch easier. It tends to make things a touch shorter. And I think it's more expeditious for all the parties involved. So that would be a suggestion of mine. The other thing that I want to focus on is when you have an employee claim, you have to check into the availability of insurance. There are a lot of policies that remain in place that will provide coverage for E&O, D&O, that kind of thing. And as in-house counsel, who I think I'm talking to, but perhaps outside counsel also, not recommending the consideration of insurance coverage it is a bad thing. So you want to check that as soon as you can, and you want to think it through, right? And I'm not an insurance attorney, but I know enough to ask an insurance attorney in those circumstances. So falling back onto the big picture, when you're confronted with potential litigation, I guess the first thing you would do as a general counsel or an outside counsel, you both need to do it, is to consider the corporation's needs at the outset. What is the goal here? what are we going to try to achieve? What is the downside? What is the reputational risk? Reputational risk can be huge. And CEOs, COOs, CFOs focus on these kind of things. And it's what their job relies upon. So, because you're working for them, try to help them. One of the most important things you can do is to focus on the corporation's needs at the outset. Sometimes they're not obvious. There might be a potential sale in place. There might be stock issues. There might be a lender float, There might be all kinds of things. You got to make sure you know those so you can do the best service to the company. And so I'd highly recommend you. And in my experience, the folks in the C-suite will appreciate the fact that you're asking. The next thing I would point to is that at the start of a case, when you first get threatened with a claim or challenged with a claim, is that it's really worth putting in a few days, and take the few days. Close your office door. Take the few days. Assess what the impact is, what the reasonable settlement value is, or if we're going to move to dismiss or later move for summary judgment. The planning is worth much more than the work. I've dealt with a few cases over the decades. The planning can take 90% of the time, but it results in the execution. A lot of people dash right off to court or what have you, and they follow the advice of their insurance carrier's appointed counsel. The obligation of a general counsel or a litigation counsel is to do the hard thinking. So I offer that to you. I think it's very important. I would also, next, new paragraph. The law firm you retain is very important. So my going rate currently is $1,065 an hour, right? There are plenty of lawyers who work for $230 an hour. You might get a better deal with me. So the point of the matter is, you want to, and I'm not trying to show off, that's not who I am. But the point of the matter is that you want to retain the right people for the right job. And it actually is cheaper in the long run, believe it or not. It truly is. You want to make sure you have the right face for the right case, if that makes any sense. So, next paragraph. The more homework you do on the claim, the factual issues, that will save you money. That will also save the company money. And it's important, and it will also help the lawyer. There's nothing worse. Well, there's a lot of things worse, but one of the things that's worse as an outside counsel is when we have an inside counsel who doesn't really care. So if you are a lawyer representing the company, I would most respectfully advise you to do as much investigation as you can. And that will help the outside counsel. One thing to make clear is that you do not represent the employee. You represent the company. and there is no privilege between you and the employee. And I always announce that at the beginning of the discussion. And I've never gotten any pushback. But we want to be clear that they don't think that you are their lawyer and not the company's lawyer. So there are a number of ways to approach this. There are associations of general counsel who have annual meetings, and they're actually quite useful. One of the things that I have experienced over the years is I'll have an inside counsel who's been with the company or the industry for decades. Well, I have been with 40 other companies, right? And so I see how they do things, and that's what I can provide in terms of an objective approach. And so I would strongly encourage, in anticipation of litigation, because litigation is inevitable, that people who are in-house coalesce, attend these kind of meetings, and get the collective wisdom of the group. I'm lucky enough as outside counsel to have that collective wisdom. When you're in one shop for 20 years, you don't get that. So I would encourage that. In terms of retention of lawyers, the least expensive is not the best idea. I'm sorry to say it, but that's how it is. I had a client years ago, whom I obviously cannot name publicly, where their head of litigation said, "I just realized you're doing this case all by yourself." And I said, "Yes, I am. And I'm also saving you a fortune. It's too complicated. I don't feel like training some associate to do it. So you're saving a fortune." And I never got a billing complaint from that client again. You have to hire the right woman or gentleman for the matter, right? And you actually can save money. You can save money at $1,065 an hour versus $230 an hour, because they'll bill you 100 hours at $230, and they're trying to learn the stuff that some of us older folks know. So I offer that to you for consideration. Another thing I would add, next paragraph, is intelligent clients do not hire law firms. They hire people. Any law firm has terrific lawyers, and they also have Fredo from The Godfather. And so the point of the matter is, you hire people, not a law firm. There was an old statement years ago that nobody went wrong by buying IBM. You want copiers, you buy IBM. If they don't work, you say, "Gee, I don't know, I did the best I could." Intelligent counsel will hire people, not firms. And I can't name names. It's not appropriate for Westlaw, and it's not appropriate for me. But I offer that to you for your consideration. People you trust, I think, are your best option. So then, next paragraph, we'll talk about fees. How do you pay us? Gee, I don't know. You have to select the fee structure that works best for your objectives. One of the things that bothers me a touch is some potential clients wish for a blended rate. They want a blended rate. All partners, all associates, all counsel, whatever, we charge the same amount of money. Okay. If you ever want to meet Fredo from The Godfather, that's a great way to do it. Because, every firm has people they'll be happy to throw into a blended rate. I highly recommend you pick the best person for the exercise rather than the cheapest, because I've seen it both ways. There are various ways, next paragraph, there are various ways to do alternative fee arrangements. The seminars for in-house lawyers proclaim them happily. They're called AFAs, right? The question is, whose best interests are at stake in those situations? Because, if you go with a blended rate, it may not be the best people you could get. And I'll just say that. The retainer agreement, important thing. To me, nothing annoys clients more than charging them for Federal Express, conference calls, that kind of thing. Postage. Oh, wow. I need your $2.26 for the postage. No, that's not how we do business, right? So that's just something for outside counsel in this paragraph I would offer to you. Write off the FedEx, write off the lunches, write off the postage, that kind of thing, right? Okay. So going back to the alternative fee arrangement issue, you have to understand when you look at it, it's just math. And does it make sense for you? And are you going to get the right representation? Because that's what's most important. That's what we're supposed to do as lawyers, is do the best we can for you. It's honestly not a fee grab game. The concept is that we do what we can do. And it's a cooperative relationship, at least hopefully. So that's the concept of it. So go over it clearly with the lawyer and discuss the expectations. Now, that's a nice segue into my next comment, which is it's entirely appropriate for either party to ask, open paren, insist, close paren, at the outset of the litigation to have a detailed plan and budget. One thing about, and it really is true in corporate law as well as in litigation, we can't predict what's going to happen. We can do our best. We can plan from our experience and that kind of thing. But it's appropriate for a client to ask for it, and it's appropriate for counsel to furnish it. And obviously, it's not a guarantee. I can't guarantee you anything, right? A lawyer's like a surgeon. I don't know what I'm going to find. I don't know what's going to happen. Oh, well. But it sets the stage for budgeting. The CFO will appreciate it. People won't be surprised. And I think it's very conducive to effective relations between a client and a lawyer. And so I do encourage it. That nobody wishes to do a budget. That's not something we look for. But we should, and we do. And for inside counsel, you should insist on any detail you wish. And it should be furnished. And by the way, it should also be billable. But that's, what can I tell you? The next paragraph that I wish to go to is the relationship between inside counsel and outside counsel. There is a lot of stress on both parties. Inside counsel, litigation, or even the corporate side is not a cash generator. It's a cash drainer, right? And so the CFO, if you're inside counsel, will view you as a cash depleter. That's just how it is. And the outside counsel wishes to get paid, as she should. So the trick is to understand the sensitivities in the company relating to that. It's extremely important. And particularly, as outside counsel, I can always get fired and I'll get another client. That'll be okie dokie. I'll find one. As inside counsel, it's more personal. But you're not a cash generator. You're an expense. It's just how it is. So the better you can work with outside counsel on expenses and with your CFO, I highly recommend. It makes your position more stable and it makes you better appreciated. And that's for outside counsel as well. So I offer that to you just based on my experience. The value of a settlement. Let's play with this for a while. Let's say you have a class action where the potential downside is $200 million. I'm just picking a number out of the air. $200 million. Okay. And the chances of you losing 0.5%. So what's the reasonable settlement value? The point of the matter is that when you have a situation with a big potential liability, it's much easier for the C-suite and the board to settle it rather than try it. You'll be stunned at how few class actions actually get tried. Because if you settle that $200 million case, and I'll get my math together, but whatever. If you settle it for 5% of the possible exposure, it can get buried in a footnote on the 10K or 10Q. If you try it and you lose, it's a life-changing experience for the C-suite. It's just how it works. And there was an old saying, I played football years ago, right? Decades ago. Protect your quarterback, right? And that's the C-suite. And this is for both inside and outside counsel. So I think one of the best things for a relationship between trial counsel and a company, and particularly inside counsel, is to have mutually common expectations. Because some people, I apologize to some of my fellow professionals, do not do that. I think it's very important to be aligned. And so even in simple or complex litigation, I think the development of a litigation plan working together, right? And working with the C-suite and working with the witnesses is just critical to both outcome and cost management. And it preserves everyone's expectations. And well, I guess I'll leave it at that. You see what I've said. Some lawyers are darn hard to reach. Well, that's not the lawyer I want. I want a lawyer who's reachable. I want a lawyer who protects inside counsel. I want a lawyer who protects the company. I want a lawyer who cares, right? And so if you find yourself in a spot with somebody who is not that person, that's pretty easy. Delete them and find one who cares. Honestly, you don't have to put up with it. It's not in our moral code for decent lawyers. So if you have an outside counsel who is not being responsive, fire her or him, and pick another, because you are, of course, paying for them, right? So a lot of in-house counsel are corporate lawyers, and I have been one myself, and in addition to being a litigator and so on and so forth. But, you don't know FRCP Rule 56 or whatever. You're relying on bloke to protect you. And then if you can't find bloke, well, gee, that's not that great. So find a new bloke. That would be kind of my advice. There's sort of a principle that outside counsel should return every call, email, text in the same day. I hew to that. I don't get that myself, but that's just sort of a belief. What I would convey after these decades is that you're entitled to insist on that. So I offer that to you. The litigation plan, things do change. Litigation is a moving target. I don't know what the other side's going to do. The budget may change. I don't know. But it's good to have a developing plan and to stay in context of it. One thing that I've seen is I've been asked for budgets countless times, but I've never been asked for an updated budget. My advice to inside counsel is ask for an updated budget. Cost control, right? An outside lawyer should be able to provide same. And you, on your side, should be entitled to receive same. So I offer that to you for consideration. The litigation plan, and these are two different subjects, right? But they kind of interlock a little bit. The litigation plan and the budget are related, but not completely tied together. It's got to be an evolving discussion because one cannot predict what the other side will do. I would suggest that counsel work together, or if C-suite is at issue, or God forbid we have a company that doesn't have a general counsel, that we have constant conversations and make sure we're in the same place about what we're going to do. It makes the relationship better, it saves money, and it frankly makes the representation better. So, next paragraph. At the outset, and this will be an evolving thing, the litigation team needs to create a detailed outline of the case. And what do we do with it? Where do we go? You know, it's always nice to know where your car is heading, right? And so for inside counsel, I would recommend that you demand such a thing. For outside counsel, I would recommend that even if not demanded, you provide such a thing. It's reassuring, it's confirming, you have the acceptance, and there you are. It's just a question of being on the same page. Then, you know, we go back to the cost-benefit analysis, right? You know, I've settled cases that I really, you know, honestly, I don't believe were meritorious, but the finances of them kind of dictated that they should be settled. That's unfortunate. That's just the world in which we live. But you should assess the cost versus burn factor as inside counsel and also as outside counsel, right? Because as outside counsel, you have to take it from the client's point of view. And that's very important. And they might not be as sophisticated as you, or they might be a lot more sophisticated than you, but it's teamwork. And I think that's incredibly important. It's the liaison relationship in litigation. So let me just take a next paragraph for a moment. You know, 2008 was an interesting time. And what I saw was a great reduction in litigation. And I think that's probably not a bad thing. Corporations became less interested in trying cases. Litigation budgets crammed down. They just did. You know, and as a litigator, I can't really argue with it. Litigation, they say, is the sport of kings, right? So if you're a king with unlimited money, go for it, whatever. And there are some reasons to do it. But if we can head it off at the pass, I view that as a better thing. The next paragraph. We have a new generation of workers. They have different expectations. They are completely entitled to them. And I don't think they're necessarily wrong on many of them. What we have to do as litigators or as corporate counsel is make sure that the values of the company hew to the current standards. And I think that's very important. And they're entitled to the current standards. And so we owe them that respect, and that's how we retain them. So why am I talking about that? I'm talking about that because it comes down to internal policies and procedures and how the law department in the company and how outside counsel treats people. And, you know, I'm 56, right? I'm kind of the old guy now. The point of the matter is we need to be inured to the modern times. And that will prevent litigation. That's the whole point of my 3-minute peroration there. That's the whole point. And honestly, litigation is not desirous for any company. It's better if we can relieve the problem, or better yet, prevent it from the start. So one of the other things that I would share with you, and this is principally directed at outside counsel is that you have to remember that you are the face of the company. You are representing the company in the public realm. You are speaking for the company in everything you file. You are entrusted with the respect of the general counsel's office and also the C-suite. And so your obligation is to represent the company in the most appropriate way you can. And I will tell you from experience, companies are different, right? They're not all the same. They vary. They have varying corporate morals. They have varying ethics. They have varying credos and that kind of thing. The trick is, it's not a trick, but the gift of it is, understand the company you represent and care about the company. Understand their business. Don't be casual about it. Understand what they do, what they want, what their goals are, and for a guy like me, understand the finances. And that will make you very valued and will also preserve the relationship. You would be stunned and surprised at how many people, they're lawyers working for bloke and bloke or whatever, and they don't care about any of that. But if you want to have a lasting relationship, you understand the company, you protect the GC, you protect the C-suite, you protect the board, you protect the shareholders. That's really what your goal is. And, Miss Bloke that has her employment class action claim, we can deal with that in due course. But the trick of it is to be present in the moment. And I truly recommend that to you. So what do we do when a lawsuit gets filed? Hopefully, we can avoid having a lawsuit filed. For in-house counsel, which is the kind of subject of this, it's great to avoid having a lawsuit. It has to be handled very carefully. Obviously, an HR issue, working with the general counsel or a deputy, right? It's terrific if we don't have a lawsuit. If we do have a lawsuit, what do? Okay, the complaint gets served. You might have known about it in advance, that there would be a suit, or it might have just parachuted in on you. That happens sometimes. I've seen that one. Either way, if you had notice in advance, you should already have counsel involved, unless you wish to do it in-house. I have a couple of companies that have, of course I can't mention names, but that have very well-developed litigation departments in-house, and they do it themselves. But if you don't, it's good to get them involved early, and it's nice to get the thing off the rails if you can. And I highly recommend that. One thing that I'll share with you, and I've mediated over 100 cases, lucky me, but one thing that I'll share with you is sometimes a claim talks about money, but it's really about hurt feelings. And sometimes you can save a ton of money by assuaging the hurt feelings. It's very effective. Apologies are always nice, but in the context of a settlement, not in the context of we're just going to apologize. But that actually works pretty well and has saved some of my clients a lot of money. So I offer that to you for consideration. I worked the appellate mediation program for one of our Court of Appeal in the state of California when I was a baby lawyer. And so I've seen this done, and it's very effective. And so I offer that to you. The next thing I would say is, if you really have a contentious litigation, there honestly needs to be a cost-benefit analysis performed, a realistic assessment of the strengths and weaknesses of the case, all within the attorney-client privilege, and every document should be marked as such. But so for the inside counsel, right, your job is to protect the C-suite and protect the company or C-suite, right, chairman, CFO, COO, that kind of thing. But they have to report to the board, and the board has to answer to the shareholders, right? And the shareholders don't hire you. The board doesn't hire you. The C-suite might hire you. The GC is likely the one to hire you. But you have to protect the company, and that's very important. And so timely sharing and reporting evaluations of what is going on, especially in contentious cases, and this would, of course, be within the attorney-client privilege, is very important because it provides comfort to all involved. And for the avoidance of doubt, it actually means you'll keep being the lawyer on the case, okay? So lawyers who are emotionally absent, that kind of thing, that really doesn't answer well. And it's not doing a service. So, again, I will hearken back to the concept of percentage of loss and impact and that sort of thing. A paragraph I'm throwing in here now, hearkening back to what we were discussing earlier. We need, like I said, I'm 56 and change. We need to be cognizant of the different values or the different perception of values that people younger than I have. And these are the people who will run this country. And I highly recommend that corporations focus on this. And the in-house legal department is particularly qualified to focus on that. So there are other things I can recommend. If we're going to try a case, let's do a mock jury. Let's look at that. Let's see what they have to say. I have something in litigation that I came up with myself. Most of my stuff I borrowed from others, but this is unique to me. If you have a case, you have a claim against you, okay, against the company, right? Lawyers can come up with a whole bunch of wonderful answers to all kinds of issues. There's an old joke that if you want 50 opinions, just ask 25 lawyers. But what I came up with was what I called the bus stop test. Here's the bus stop test for you. When I worked on Olympic Boulevard in Los Angeles for decades, we had a bus stop, and it was right outside a welfare office. And there were a lot of people waiting for buses, right? And so when I'd be having a case discussion with people, and they'd come up with theories and ideas, some of which I found rather exotic, I would say, well, you know what? I don't agree with you, but let's go down to the bus stop and just pick anyone. I don't care who. Let's ask them what they think. Right? Not pitching it either way, But as an in-house lawyer or an outside lawyer working for a company, consider the bus stop test, because they will tell you what they think. Just pick any person, and they'll tell you what they think. It's amazing. It's like a free mock jury. So I offer that to you because it's a reality check, which I think is necessary and needed in litigation matters. So I tend to recommend it. Now, I have to confess, I've never practiced it myself. I can do the bus stop test on myself. But I do recommend it. Closing thoughts. The trick is for inside and outside counsel to work together cooperatively and to support each other. And it's really, for you outside counsel out there, it's really the inside counsel who need the support, right? And so you got hired. It's your obligation, right? It's your duty, etc. Making them look good makes you look good, makes you get hired, makes a relationship. Take care of the company. Remember the needs of the shareholders. That's really what's important. So among the other things that I would recommend for the in-house counsel, but also for the outside counsel, I highly recommend task-based billing. And one of the nicer things about billing is to identify the value that is conveyed. So I could write a time entry that says, interview Mr. Bloke. Well, that's nice. But how about interview Mr. Bloke concerning his recollections of the accident? See, it conveys value. And it will make your bills more likely to be paid. And it will also convey to the client, this is for you inside counsel, what we've actually been doing. And this is a lecture I've given many times in the past. But I think it's very important. I had seen, you can't make this up, I had seen an associate's bill once that said work. Wow, work. Not exactly what I wish to see. So the point of the matter is, if you can convey as outside counsel to the inside counsel that you're actually achieving something, your bill is a lot less likely to get written down. And, we still have to buy holiday presents for our families, so you don't want your bill written down. For inside counsel, same message pointed in the mirror. I would insist on detailed billing. I don't want to hear junk like work. I want to hear what's being achieved, right? Because why would you pay the bill if you didn't know what it was for? So I offer that for your consideration. For both inside counsel and outside counsel, I think you want to have a defined team of who is working on the case. You want to have a lead partner. You want to maybe have a more junior partner who candidly does a lot of the work. You want to have a good dedicated paralegal, and you want to have a defined team. So when emails, and I mean this extremely seriously, when emails are done about something on a case, I like to see everybody copied on it, so they're knowledgeable about what we're doing, right? I also would suggest that there are external experts who should be consulted along the way. I have a few myself, retired FBI agents and that kind of thing, accountants, that are extremely useful. And candidly, for you outside counsel, they're much cheaper than lawyers. So, I think that's something. What you want to do for either inside or outside, what you want to do is create a team, and that's the team, and we stick with the team. The team may change, I don't know, but at least we're all on the same page. Another thing that I do, if it's a significant case, weekly scheduled meetings. Everybody attends, the most senior to the most junior. We all attend, and we talk it through. And it's probably kind of expensive when you think about the hourly rates, but it's actually really quite cheap when you think about getting everybody on the same page. In terms of document preservation, I do wish to speak to this, and I mentioned the Upjohn case earlier in this video. Inside counsel is best positioned to figure out how to preserve documents. I have been in situations where I've had opposing counsel. Well, okay, let me walk it back for a second. Inside counsel should insist. Outside counsel should insist, right, that a document preservation notice goes out to any involved parties. And by documents, it's not just paper. It's emails and texts and those kind of things. I have had the unhappy circumstance of having opposing counsel who has attempted to torture my team about document preservation. And I thought we'd done a pretty fine job. But I encourage you to focus on that and to put a lot of effort into the preservation memo and email that goes out. I think it's extremely important. And the other thing to recall is, for you in-house folks, us on the outside, we don't know who your personnel are. We might if we've been representing you for half past forever, but we generally don't. You're in a better position to help us. And it's important to protect them, and it's important to protect the company. And I won't cite cases, clients. I'm just going to skip it because it's Westlaw. But you understand what I'm getting at. And there's not many things more embarrassing than being on the short end of a document preservation issue. So I emphasize that. The other things I would say in terms of litigation staffing is you want to identify how many people you actually need, right? Who is the team? And that goes back to what I was saying earlier. You get the team, they're on an email, that kind of thing. I have a joke, and it's not really a joke. It's more frustration. But what I say is, when in doubt, add more lawyers. Golly gee. But that's what companies do. No problem. I got 20 lawyers working on this. Let's get another 5. I don't recommend that. I'd rather have 20 who are very focused on what they are doing. And for in-house counsel people, you're in charge of managing that. The appropriate number of people on the case and the appropriate level of expertise and knowledge is very fundamental. And what I tried to speak to earlier was This may involve increased costs, which it will look like from the outside, but it actually results in savings as long as you have the right people. See, that's the key. For you in-house counsel, and also for us outside counsel, we should think of it too. The right people make all the difference. I can do more with 3 people than some firms can do with 20. It's just how it is. That's the most important thing you do when you're staffing a matter. And so I recommend that to you to the extent you like the concept.